while they're looking at that, I'm going to address the audience. I know there's a lot of people here today. People are going to be going in and out throughout this hearing, but I wanted to say for the people that are here now, a couple of housekeeping matters. Please take a look at your phones. I don't know if you have an Apple Watch, anything like that. Make sure that they are turned off so that they don't start ringing or vibrating in the middle of the trial and be distracting. Second of all, there are instructions that I'm giving everyone, but it should also be on the door. You cannot use a cell phone to take photographs or videos unless you have a media license and have been granted permission by the court. Do not take pictures of any of the jurors. Do not take pictures of any of the witnesses, the lawyers, the people involved. If you post something on social media, I more than assure you they will find you. It has happened in the past. The consequences are contempt of court and jail time. So please take note, look at the phones now, make sure they're off, and don't be looking at it where somebody thinks that you're taking a video. If you have meta glasses, please take them off. If anyone sees a little green light or a little red light on your glasses, you will more likely than not end up being in jail. So please check your glasses. I don't want to have to start this all over or have this type of a hearing, but I have to say it because it wouldn't be the first, second, or third time that it happens to me in particular. It happens to all the courtrooms, but I give this admonishment in advance because of the experience that it has happened before. So yes, we even had meta glasses. That being said, I know that there is going to be a lot of testimony that's highly emotional. There are family members on both sides here. Please remember that this is a courtroom. I don't anticipate we're going to have any issues, but I give this same admonishment as I do in every other homicide case. I know it's very difficult to hear. I know that both sides are going to hear allegations against a loved one that's going to make them unhappy. If you cannot sit through it quietly, please exit quietly. We don't want anything to happen in front of the jury that's going to cause us to have to start all over. So I just wanted to bring that to everyone's attention. For your concerns, the media might get people from the audience into the photographs, but they're going to make a concerted effort not to get the faces of the jurors because they are concerned for the sensitivity of their safety and their privacy for now. All right. Anything else you all want me to address?
Yes, Judge, there's one additional issue. So this goes to the court's ruling excluding the confession of Wilner Yacinthi. And just to give a little bit of additional information. Wilner Yacinthi was the individual officers got information through a confidential informant who was working with ICE that Wilner Yacinthi is a known hitman and he confessed to the crime. The court excluded his testimony for a couple reasons, excluded any reference to that cross-examination on that, anything related to that confession for a couple reasons. The first was because in Detective Dominguez's report, it said the only information there is that this individual said he killed somebody with a .38 caliber, and the court found that that wasn't sufficient information to link this to the murder of Bryan Pata and make it, meet the credibility requirements under Chambers versus Mississippi. The second is because there was information provided to the court that the hitman who allegedly made this confession was deported to Haiti and died in 2010, and therefore the officers really couldn't do any additional investigation or follow up on that because he had passed away. So the court said that this isn't something that we can bring in for lack of investigation or what the officers did. Since that time, we got some additional information from ICE. We sent a number of 2 letters. I believe we referenced that last time we discussed this in court, and the initial one was denied. We just got a response to the second one, I believe on Friday of last week. That included a number of reports that was written by the ICE officer who initially made this information available to the detectives for the Miami-Dade Police Department, and it includes some additional information that wasn't included in Detective Dominguez's report that would affect the court's analysis. The first is it includes specific language discussing what this confession said, where he said, "I just killed that kid from the University of Miami." So now we have a specific statement, unlike what the court found about Dominguez's report, a specific statement linking that confession to the murder of Bryan Pata. It also includes information about a .38 caliber handgun, and in looking to Detective Dominguez's report about the date whenever this confession was made, it was approximately 3 weeks after the death of Bryan Pata, according to Detective Dominguez, and then according to the new ICE reports we got, 3 weeks after, well, it doesn't say specifically 3 weeks in the ICE reports to be clear, but the confession was, I just killed that kid from the University of Miami. I get paid to perform hits. So I believe that that would at least affect the court's analysis as to the credibility of this confession. The second issue, well, these are intertwined. Between 2009, December of 2009 and 2011, there is an operation. The City of Miami Police Department and ICE are trying to locate Wilmer Yacinthi because they have this information about the homicide, and he's also illegally in the United States, so ICE was trying to deport him. There are a number of City of Miami police officers who are referenced, but their names are redacted, who, in speaking with ICE, saying, I've seen this guy in the area, I've seen him around this location, he looks familiar to me. The City of Miami and ICE were never able to locate him. None of that is referenced in any of the reports in this case. Miami-Dade Police Department, as far as the information that we have, was not involved in any of this. They didn't try to go to any of the locations where this person was seen. They didn't try to do anything to locate this individual. And this is happening in December of 2009. The last entry from Detective Dominguez's report, and I believe the last entry until the new reports, whenever Detective Segovia took over, is in November of 2009. So it doesn't memorialize any of this. So now we know that there's this investigation by other departments trying to find this guy, seeing this guy, knowing where this guy is. I have to imagine that that was communicated to Miami-Dade in some way, but there's no information about Miami-Dade's involvement in that. The second issue...
So wait, before I forget, are you asking if there are reports, or do you need to ask if there are reports reference that in any of the Miami-Dade files?
From what we have so far, there is nothing in any of the Miami-Dade Police Department reports that would reference that search, that investigation, or Miami-Dade's involvement in that.
Okay, so you're not asking for us to ask the detectives about that specifically because you've looked through and you believe it's not there? Okay.
Correct. We're asking for the court to reconsider the ruling excluding.
Okay.
Right? Now, as far as the information that was put before the court at the last hearing about this individual being deported to Haiti and dying in 2010, I think there was a miscommunication between officers and what officers were saying in this case. According to Detective Segovia, at some point, he testifies that it was the CI, the source, who was deported to Haiti and died, not the actual hitman who made this confession. Now, in 2011, so after the earthquake in Haiti, the ICE agent reaches back out to the Miami-Dade Police Department and says, we have information that this individual is now operating in Marietta, Georgia. The ICE agent writes this report saying that based on his investigation and his understanding, this gang that the hitman was involved with, according to these reports, the hitman was involved in a gang that originated in Miami-Dade County, and that gang then spread its...
Do you know what the name of the gang is? I'm only asking because of the fight that you referenced in the past.
So that's redacted, Judge, the name of the gang, but based on sort of context clues and additional research we've done, it was a Haitian gang, according to these reports, that originated in Miami-Dade County in the Little Haiti area. And going back to the fight that happened at Club Life, those were also individuals who were affiliated with the Haitian gang in the Little Haiti area. So they reach out, the detective reaches out, the ICE detective reaches out to Miami-Dade Police Department and says, this guy is in Marietta, Georgia. We have information that he's in Marietta, Georgia, still operating. He had moved up there because this gang had spread its influence up there, and they're now transporting things from Atlanta down to Miami-Dade. And the last entry from the ICE agent's report is that he hasn't been able to get in touch with anybody from the Miami-Dade Police Department, and it ends there. And again, there's nothing about any of this referenced in any of the police reports from Miami-Dade County in this case. So to the extent that they're given information about this person who confessed to the crime, specifically mentioning the person from University of Miami 3 weeks after Bryan Pata was killed, for them to either ignore or not respond or not go to Marietta, Georgia to try and find this guy is certainly something that needs to be presented to the jury judge, especially with all of the information that all of the other number of witnesses had testified about this fight, about how the fight involved known gang members, about after the fight, one of the known gang members said, we're going to get you, about information that Bryan was aware of about there being a hit out on his life and Willie Williams' life. And then we have a hitman now who's saying that he did it according to a confidential informant, and in the ICE agent's report, he says this is a very reliable, quote, very reliable confidential source, which I would imagine means that he had provided some sort of reliable information in the past that he was able to verify. Of course, none of those details are in the reports. Maybe they're a little bit redacted. But this comes from a very credible source, and there's inside information, the caliber of the firearm, that would not have been known to the public. And Wilner Yacinthi, the hitman, his sort of position and involvement matches up directly with this information that police already knew from this Club Life fight and the hit and all those threats. And then they get information he's in Marietta, Georgia, and just don't follow up on it. They don't investigate it. I think at this point, Judge, that statement, now that it links up the University of Miami, there's this insider information about having a .38 caliber firearm, that would, and the fact that this confidential informant was deemed very reliable, that would then meet the credibility requirements under Chambers versus Mississippi. And this is something that the jury should hear about, Judge, to hold this information away from the jury, especially the fact that the Miami-Dade Police Department didn't follow up on this, didn't investigate this, didn't follow up on the 2011 Marietta, Georgia information, never interviewed, as far as their reports indicate, anybody who was involved with any of the gangs. That's certainly something that the jury should be able to consider. Judge, it would violate Mr. Jones' due process rights to not have the jury be able to consider this information.
So I understand you received this late Friday.
Correct.
And Monday courts were closed.
Correct.
State, have you had an opportunity to investigate any of this or look into it?
I just read it after I realized after the two letters, Mr. Maroney let me know that there were reports. So I just finished reading through the reports. Your Honor, our position is the same under the Chambers v. Mississippi analysis. There's still hearsay statements in this case. Here, those hearsay statements are alleged to have been made to a confidential informant who then told them to a special agent. So they go through two levels. We don't know who the confidential informant is. The defense has not yet deposed the special agent, which they were just given access to, like once we're in trial. But in my reading through the report, so I don't know if Mr. Maroney can point me to something different, it says that the investigation was initiated in July of 2009, 2.5 years after the homicide, when the confidential informant had just been given the information. And the information referenced a recent homicide of a University of Miami. I don't know if it said football player or if it just said University of Miami. It says football player. But this occurred 2.5 years later, not 2 weeks later, not within. So if Mr. Maroney can correct me if I'm wrong, but the chronology of events that's in the report is different in time. I don't know what witness they seek to introduce these statements into either.
So here's where I'm at. I think it merits the opportunity to look through that. You've just been granted the deposition, is that right?
Yeah, so they said that they would give a limited deposition. They haven't provided their specific availability yet.
I mean, I need certain answers before I can make a ruling. For example, when did the CIA say this statement was made? Was it 2 years after? Because then it wouldn't be as relevant. Or was it 3 weeks? I need to know who is it that went to Haiti and died? Because we were under the assumption it was the alleged hitman.
And when I read the reports, it references Wilmer Yacinthi, which is the hitman's name, that he goes back to Haiti. So the reports are all ICE, the Department of Homeland Security. It's their efforts to locate him. So initially it's in Miami, where, as Mr. Maroney said, they contact the city of Miami Police Department, not Miami-Dade. This is for them. They already have a deportation for this person. For the hitman. So they are going to locate him because it's known to them that they have this deportation order and he is supposedly still in the area. So they go to locate him. They don't locate him. They do their investigation. Then it looks like in 2011 they get information that he is still in the country, that he's in Georgia. They send that information to the Atlanta office. So these agents are no longer investigating because he's in another part of the country. And those agents go out to investigate. So this is still a situation where the federal government is trying to locate someone to deport, and then maybe Miami-Dade is told some information, but also I would bring to the court's attention, I don't know how many if there were other football players, but I know that Sean Taylor was murdered a year after Bryan Pata in November, so that's even closer in time to this statement.
Well, that's why I need to clarify when the statement was made. Also, from what you're telling me, it gives more credence to Mr. Maroney's theory that the person who died in Haiti may have been the CI first, because wasn't the death in 2010, and you're saying that the information was that in 2011 he was in Georgia?
I think that's what it said.
And Judge, to clarify the timeline, so at the time when the confidential informant provides this information to ICE is in June or July of 2009. So it is, sometime after. But then you look to Detective Dominguez's report, and it's clear that there was a number of conversations here. And in Detective Dominguez's report, he says that this confession, the confession he's being notified about from ICE, was 3 weeks after the homicide had occurred. And I don't think that there were any homicides of University of Miami students in the 3 weeks following the death of Bryan Pata. So I think that is the timeline, at least as far as Detective Dominguez goes. In the ICE reports, there is a reference about Wilner Yacinthi self-deporting, which again goes to this timeline that statement had to have been made before this July 2009 interview, because the confidential informant says he self-deported 9 or 10 months ago, but then after he gets this information, then they start this joint operation with with the city of Miami, saying they've seen this guy in the area, he frequents this, he frequents that. So my sort of putting all of this information together is that he self-deported 9 or 10 months before the confidential informant gives this information in 2009, makes his way back into the country, or potentially he didn't self-deport, that was just the confidential informant's understanding. But he's back in Miami-Dade County in December of 2009 when the City of Miami Police Department is trying to find this person. As far as them just trying to find him for deportation, I would have to find the specific line. I don't have it off the top of my head, but the ICE agent in his report says that this person is wanted for illegal entry and murder. He says he's wanted for murder, which would have to be the information about the homicide.
He could, if he's a hitman, it could have been any murder, but
That's fair.
there's multiple questions. Here's where I'm thinking. In order to be able to make a fair ruling, I need answers to a lot of the questions, including some of the redacted gang information, because then that would also address some other issues that you've brought up. I would need to know who it was that died in the earthquake. They should have that information. And I don't know how quickly you can get that deposition done, but from what I'm hearing, we're giving jurors outside for opening arguments. And I guess let me ask without guessing, was it something that Ms. Maroney, you all would intend to use in opening arguments? We're gonna talk
Yeah,
about
if we
it?
were able to, yes.
Well, my question comes because I'm saying, do you want time to investigate and do that deposition before opening arguments? I don't see the advantage of doing opening arguments now without including that information. If it's something that's going to come out, I would assume that you might, that's your strategy, want to discuss it amongst each other and decide if you wanted to include that in your opening argument. So if it's something that's going to be admissible, I don't want to foreclose you from talking about it in opening unless you're okay with doing that. But to what point? Because then we have to take a pause for you to do that investigation.
What I would suggest is obviously we need some time to speak. Maybe we could send the jurors out now for an early lunch. We can take some time to have a conversation. We can see if we can get something scheduled to see when we will be able to do that and readdress. Is there any issue with that?
I think that makes no sense.
I think that makes more sense also, which is why I was saying I don't think it's prudent to go forward with opening arguments until we have some answers to some of these issues. I would think that the state would also want some answers to those issues, because if there's more direct evidence to something else that you all don't know about, you'd want to know
Of course.
some answers to those questions as well.
Your Honor, just because we've often taken breaks and come back and not have the questions answered, I would just like to ask how they intend on getting this into evidence at trial, because I still think it wouldn't be admissible. And
So I'm in agreement with you. It's going to be, but it's not impossible.
No.
But depending on what some of the answers are to those questions, it may become admissible. So I don't want to foreclose them from talking about it, to then take a pause after opening arguments for a day or something. It's really not worth it. And I think that depending on what some of the answers are, it could change the strategy for both sides. If, you know,
And I would also just point out, so they're saying that Detective Dominguez has something different in his report, but he got the information from the ICE officer, so I would tend to think that was the original information.
so I get it. The state's position is it wouldn't be normally admissible anyways. But in the pursuit of justice, it's not just the admissibility. It's, I need to know the answer to those questions because it could change a lot in the trial, as I see going forward. And it may become relevant and it may become admissible if it ties back into some of the other things that have been excluded because we didn't have this information until late Friday.
And Your Honor, as far as the admissibility goes, I know the court's well aware, but sometimes the strict rules of evidence need to bend for due process. And this might be one of those situations, even if this is for some reason inadmissible hearsay that the court does not believe should be introduced as to protect Mr. Jones' due process rights. This is something that needs to be used for impeachment to call into question the credibility of these officers' investigation. This was a 15, 16-year investigation, and they just didn't follow up on the hitman. Like,
Well, let's
that goes to the credibility of their whole
Well,
investigation.
this isn't the only alleged hitman. There's been plenty of confessions alleged from all parties, including the alleged confession of the defendant, which is not going to be admissible because it's hearsay. So, in the pursuit of justice and fairness, I have to be fair to both sides. So remember, there are a lot of alleged hitmen, a lot of alleged confessions, as you have in most high-profile cases. So you have a lot of people that want to take credit for things that they really didn't have any part of. But in this case, I think it's worth getting to the bottom of it because I think it could change the status right now of the trial, and it's not prudent to go ahead with the openings just as of yet. So I don't know that you're gonna have all the answers within a lunch break. Maybe you can find out the availability of the agent to see how quickly we can do that deposition. Maybe the state can speak to Officer Dominguez and sort of see if he can delve into any of this or answer any of these questions.
I mean, Detective Dominguez was deposed and asked about these issues. I can look at that as well. But
Yeah, the only issue is that now we have some different information.
I read through the report. It seems like the exact same information, other than it was July of 2009 versus saying it's shortly after the homicide.
Okay,
Wait,
I guess I really specifically would like to know when the statement was made. Was it made in 2006
Yeah,
or 2000?
So
Technically
Detective
2 weeks after, a few weeks after.
Right, he's saying 2 or 3 weeks. The
in
state's
Detective
saying-
Dominguez's report, in the Homeland Security reports, it sounds like it's made in July of 2009. Detective Dominguez got the information he put in his report in October of 2009. I'm not sure he'll remember. I will have to read
I don't know either, but I'd like to get to the bottom of it.
In the report itself, what they make clear is that the confidential informant did not relay the information to the ICE agent until July. However, when he relayed the information, what he said is that he was playing dominoes at someone's place and someone confessed to him in the weeks after the homicide.
And what page of the Homeland Security reports are you referencing?
Should be, the ROI that,
So if anyone wants me to review the reports, I'll be happy to. If you give it to me, I'll do it over the lunch break.
I'm
But
happy to provide them with defenses.
It's
and
usually
agreements.
not something, because it's not discovery in this case, so it's not something that I see, but it would make it easier for me to understand what it is you're all saying.
Absolutely, Judge. We can send an email with that information.
Okay, so let's tell the jurors to be back.
You don't want to work on them?
What?
You don't want to work on the jurors?
Anyone object to my going out in the hallway and saying, welcome, thank you, we're gonna send you on lunch break because we're still working?
No, Your Honor.
Okay, it's better than just waiting. Okay, so I'll do that, and then we'll reconvene at like 12:45. I'll give you